In this video, I'll be talking about how to win your case in immigration court. When you receive your notice to appear, it means you actually have to appear in front of the immigration judge either to concede to the alleged facts or to deny the alleged facts in the notice to appear. Hello, my name is Bijou Ngwanda. I am an immigration attorney in the DC metropolitan area. We do work with individuals across the US and around the world because we deal with immigration laws. If you're new to my channel, please subscribe. If you're not new, welcome back, and please don't forget to hit the notification bell so you don't miss any of my videos. And I have been doing a lot of asylum series because we have been receiving a lot of asylum application into our office here in the DC metropolitan area, and I thought that doing those asylum series will help you basically come up with your defense, or basically help you with the process, along with the process. Okay, so that's the intention of those asylum series. And we took a break last Sunday because we had to address one specific issue, and I came back again just to continue with those asylum series and go a little bit into the details of how you can use asylum as a defense. So basically, we have two type of asylums application. It's either affirmative asylum when you apply within the 1 year period, and then there is another way to apply for asylum as a defensive tools for you to present to in front of the immigration court or in front of the immigration judge. Okay, let's go into it. So those type of defensive application come into play where, for instance, you get married to, that's a specific example that we're going to use in today's video. You get married to a US citizen, and you sometimes, in some occasion, you even get your green card, your temporary green card. And when you apply for removal of the condition on the green card, you get a deny. And basically, when you get the deny, it comes with a notice to appear. At that point, you have no legal basis to stay in America. So that's why you have to go to the court, appear in court in front of the immigration judge to tell the judge why you think they should let you live in the US. And one of the defense that a lot of people actually use, which is really effective, is asylum. And that's how we're going to talk about it today. When you use asylum as a defensive, affirmative defense to your notice to appear, it's really difficult because, first of all, the 1 year period has lapsed. Remember, asylum must be applied within 1 year, unless you have those two type of exceptions. And when you actually went to court and marry, first of all, you marry your US spouse, and now you have you get your conditional green card, and then when you apply to remove the condition on the green card, you got denied. So now you appear in front of the immigration judge. So what is your defense? Because the 1 year period has passed. So there is two exceptions that I am going to talk about today. The first exception, you have to show that there are changed circumstances, or circumstances materially affecting your eligibility for asylum. For example, changes in applicant country, condition has changed in your country, okay? Changes in circumstances in the US. Maybe you change your religion, so you can no longer go back to your country based on persecution. Remember, asylum has to be founded on a well-founded fear of persecution based on race, religion, nationality, belonging to a particular ideology, political ideology, or belonging to a particular social group. So if there are changes in those areas that I have just listed, then the exception applies. And that's a very common exception. A lot of people apply based on that exception. And there is another exception that you might maybe follow. You might be under that exception, so which is extraordinary circumstances, okay? Circumstances that the applicant had no control over. Maybe serious illness. Maybe you were basically sick and you missed the 1 year deadline and you have to prove it. You were so sick that you couldn't apply within the 1 year period. You have to be able to prove it, okay? And then let's say somebody died in your family, like your child, okay? And so basically you couldn't apply within, because you had this very specific, extraordinary circumstances. And in some type of application, the one that we're actually talking about today, when you try to remove your the condition on your green card and you got denied, you had some type of lawful situation. You had a green card, which is a lawful status. Now you don't have a status no more. So that's why you couldn't apply within that 1 year deadline, because you were lawful here in the US. But now that they refuse to give you, they refuse to remove based on the alleged facts in the notice to appear, whether you're denying it or conceding to it, it's just a matter of the judge deciding to the response to those allegations. But anyway, say you were conceding to those allegations, what's going to happen now? You have to show a specific exceptional circumstances, and that's a good one because you were lawful. You had a legal status. You had a green card, although conditional, but you had a green card. And when you had a green card, you were lawful. So you couldn't apply for asylum. And now they deny it, and things have changed in your country. You cannot just go back. So that's why you're asking for asylum as a defense. That's when asylum comes into play as a defense, affirmative defense. So you are defending yourself and say, please, I cannot be removed because I have fear of persecution. Things have changed in my country. I couldn't apply earlier because I was lawful here. I couldn't apply early because I had a serious illness. I couldn't apply early because things had changed in my circumstances, okay? So that's what you have to lay down on your brief, and your lawyer has to help you with that because it's very specific. You have to get it right the first time, because otherwise it goes on appeal and you get detained. It's a lot of things can happen if you don't get it right the first time. Please call our office 202-946-2922 so we can help you with the process. It's a stressful process. Trust me, I've been there in terms of defending one of my clients. So it's a stressful process. You need somebody on your side to help you with that type of process because it's really stressful. Okay, so say you don't have an asylum as a defense. You don't fit into those categories that I just laid out earlier in this video. What else do you have available to you? You can apply for withholding removal. And that's also a specific because it applies to people who have been here for more than 10 years, okay? At least 10 years in the US. That those are the people who are actually eligible to apply for that withholding of removal. And the standard is high. It says that you have to show that there is a clear probability of persecution by the government or a group the government cannot or will not control on account of one of the protected grounds, which is race, religion, nationality, social or political belonging to those ideologies. So you have to show that the government cannot control that type of persecution. And if, remember, we have talked about past persecution, and if you were persecuted in the past, you cannot say that you fear that those type of persecution will repeat themselves in the future. That's why you're applying for withholding of removal. And that's a very high standard. You really need somebody who has expertise in that subject to help you, okay? So let's go on the next one. That's the last one, available relief that you might have. As far as I'm concerned, when you face a deportation. There's another one, Convention Against Torture, okay? So if the standard says that you must prove that it is more likely than not you will be tortured if you're forced to return. That's a higher standard. And we know what torture is. Torture, by definition, is a severe pain or suffering, whether physical or mental, okay? Intentional, inflicted on a person for the purpose of obtaining information. So it is a higher standard. If you have never been tortured, you can just claim it because you have to be able to prove it, okay? So, and there are other avenues that you might use, like waivers. If you have a parent who is a US citizen. So basically, you have options in order to defend yourself against removal. But today we wanted to specifically use asylum as an affirmative defense, because remember, we have asylum like affirmative or asylum as defense. And when we use it as a defense, it's basically come later on. So most of the time you already missed the deadline. You have to be able to prove that you fit into those two exceptions that I just laid out. And if you fit into those two exceptions, at that point, you will use asylum as a defense and hope for the best. And if we lay your case in a way that is very compelling, chances are that you will succeed, okay? So again, my name is Bijou Ngwanda. I am the immigration lawyer in the DC metropolitan area. Please subscribe if you haven't done so. Share, like, follow us on social media, etc., etc. I'll come back again to elaborate more on asylum process. Just to reiterate before we close our series on asylum, but in the meantime, I'll keep you updated on any news going on with this transition. Remember, we had an election that is being contested, so I'll be updating you with, let's say we have a Biden-Harris administration, what's going to happen. I'll give a brief summary of the proposed changes under Biden-Harris administration, okay? But for now, today, we're gonna stop here. Have a great Sunday, and I'll see you to my next video. And please subscribe.